Hi,
Yeah, g'day. How you going?
I'm okay.
Yeah,
So,
good, good. Yeah, just returning your call, obviously.
yeah, I just wanted to update you about the work and also plan a little bit about the stuff that we have to do.
Yeah,
Um, so, I realized that the way in which I was covering the details um, of my analysis of the screw ups by the police, they
yeah,
were they fell into the pattern that um, I've postulated a model in respect of, and instead of going into a lot of detail every time I mentioned the mistakes they were making, I understood that it was convenient to basically define the model beforehand and use key terms. And this also um, sorts out the paper that I wanted to publish about um, the exercise of statutory discretion, like it concludes it. So uh, uh, let me explain briefly what I mean by that, so it's not
okay.
abstract. Okay, so basically, um, I've set out the conditions for the proper exercise of statutory discretion in the letter to ASIC. Um, there, I, there was like a whole paper that I did, um, and it basically set out three criteria. There's one, um, the matter needs to be sufficiently serious for the intervention of the body, uh, because it will necessarily um, have an adverse impact on someone's human rights. So when a body is actioning a complaint, they will have to take action against someone, and that will, mean that they're restricting to some extent the human rights of that person. So the matter needs to be serious enough to warrant intervention. That's
Yeah, sorry, just can I interrupt just for 1 second? Did you see what I sent you this morning?
yeah, yeah, yeah,
It was on based on, found that they're in contravention of human rights in
yeah,
relation to
yeah, yeah. I know,
mandating. Yes.
I know.
And that was 5 I too.
Yeah, I know. I said thanks to you. In
Oh, sorry, I didn't say that, yeah.
Yeah, yeah, no, that's useful. So the first thing is the intervention must be uh, justified because of the seriousness of the action or the misconduct. The second is that the evidence that is used to conclude the occurrence of the misconduct needs to satisfy some criteria. The third thing is that the process through which the criteria is assessed needs to ensure procedural fairness. So when you have those three things, then you have a proper exercise of discretion. Now, because okay, so if you don't have any of these three things, then you either have an invalid decision or an irregular decision, depending on
Mm-hmm.
the statutory construction. Additionally, when a decision is made malafidis or in malafidis, the or malified. Sorry, the S is silent. I think. Anyway, the bad faith, the the the, the additional um, hallmark that that sort of decision manifests is arbitrariness and generally abruptness. It's not um, it's not in accordance with the policy, and it's a reactionary thing, or basically if it's preempt. Yeah.
Yeah, sorry.
Can you move to?
No, I'm sitting where normally it doesn't drop out, so
Okay.
I can't explain why that would be.
Okay. Anyway, so the additional aspect of arbitrariness and abruptness is typically a feature of the decision being made in bad faith, which is basically maliciously, not just in error of law. And what happens normally in that circumstance is that when people are cornered about making that decision and about the satisfaction of the three criteria,
Yeah.
they will then basically fabricate evidence and
To justify their position.
to justify their position. Yeah, to justify their position. And essentially, because evidence that is used to justify an exceptional act can be presented in two modes. The first mode being, where it's incremental and it's spread over a large period, or it's just one piece of evidence. So another hallmark of bad faith decisions is that they rely on the second kind of evidence rather than evidence that's cumulative and collected over a large period. Generally, it will be someone giving a personal statement saying that this is what I witnessed and that's why I did what I did, rather than there being documentary evidence. And the problem that arises normally with these things is that because the person, when they're cornered and they realize that they haven't followed the due or afforded the due process, because they will need to then justify their conduct by alleging that the circumstances were sufficiently exceptional to require a sudden and serious step to be taken.
Yeah, I'm with you.
That necessarily dooms them to failure if they're checked properly, because they will have to give evidence of a remarkable event that necessitated immediate and extreme intervention for which there was previously no evidence. So the event would need to be quite serious and significant. And because when they're lying, there would not be any documentary evidence to support it, they would have given, something like a sworn statement or fabricated evidence to achieve that.
Right. Yep. I'll follow what you're saying.
Now, the problem with that is whenever you have evidence of that sort, one, because it's created in circumstances where the person is improvising and is under a lot of pressure, it will not be a conducive environment for the person to have planned it thoroughly and implemented the various things in a way that ensures consistency across the board.
Yeah.
So
vis-a-vis, say, the Fairgrave affidavit.
yeah.
Oh, no, that's partly, yeah.
No, but also like Gorton's decisions. So basically every time this happens where someone is abrogating human rights seriously and they're cornered, they will, when they're wrong, they will try to present a justification, and to do that, they would have to basically lie. And the problem with that is because their evidence fundamentally relies on their credibility, they will then be concerned about everything that they're saying panning out, which would be nearly impossible because they would have improvised a lot of things, done it under pressure, and basically in a spontaneous way. So there will always be inconsistencies between how things were supposed to be or how things were documented and what they're saying. And again, if a person is particularly careful, they can further aid the documentation of things. So these people would then be committing further offenses in fraudulently claiming stuff, and that sets off a vicious circle. The other issue that arises is that in circumstances such as that, other people whose cooperation they require, they would generally be willing to cooperate to some extent, relying on the representations of this person, and even if they know that they're not completely accurate, they're not actively taking on the liability associated with it. So for instance, if you know someone is stealing something from the office, and it's clear that they are, some people will, or a lot of people will generally look the other way or whatever. And even though both parties know that the person who's looking the other way is tacitly condoning that conduct, if they're openly confronted, they will basically say that they didn't have any reason to believe that that person was actually stealing. So they will they will keep plausible deniability open. So the person, when they're cheating, gets an exaggerated representation of the support that they can expect, and when they start getting investigated, all of those things turn against them.
Yeah, no, all that makes perfect sense. I follow that.
Yeah, so this is a fundamental. These are universal principles. They will always be relevant. So that's basically the game theory model that I'm talking about. So this thing is, I'm calling it liar's curse, because the moment they've had to lie to justify their thing, and lie seriously because of the exceptional nature of their action, they're basically doomed to further punishment, because they'll have to keep justifying the lie. Now, there's another element to it, which is that the stuff that I've done with people, which is that when you know that people are acting in bad faith, you know that they have made up stuff and not fabricated things and not complied with all the regulatory requirements. So you know that there is going to be inconsistency in evidence, and you know that even if they would have benefited from the presumption of, you know, good faith in the event that the inconsistency between records and what they did was not all that great. But because they have a guilty conscience, and because their evidence is fundamentally their word, they will be far more sensitive to the questions of reliability of their evidence. So they will try to justify every aspect of their evidence, or say that they did everything perfectly, rather than, you know, admit relatively innocuous errors. And they will also be very sensitive to any attempts to expose the irregularity in their evidence. They'll be very defensive about it, and they'll be easily paranoid and perturbed by that stuff, because in their mind you're basically invoking a doomsday scenario for them, because, you know, their guilt can be exposed through the inconsistency in the evidence. So they will be seriously affected by behavior which is not in itself extremely dreadful. So now, to justify their overreaction to relatively simple steps, they will need to present an image of the person who's taking those steps as someone who's overly aggressive or capable of harming people, because they have to justify their nervousness, their discomfort, or whatever, and they have to prejudice the other people against that person. So they start creating a myth about that person to the other people, and the other people start buying into the myth, trusting what the representations of that person. So they make a monster of that person, which makes them scary to all the other people and makes their work in some circumstances more effective, because, you know, the whole fear thing, it gives them power and leverage. However, because officially nothing that they can say will be a reasonable justification for fearing that person, the institute or the organization that they're part of cannot recognize or understand that that person is scary or intimidating. And that's where there's an asymmetry. So when that person tries to invoke regular steps, the organization will have no basis to oppose them, but the person who has always counted on demonizing the person to, you know, prevent their own investigation of them, they will no longer be able to use those mechanisms. And the other thing that will happen is that there will be a disconnect between the way in which everybody else has been dealing with the person and the way the rules require them to deal with them, for which there will be no reasonable explanation. And that's basically what I call the folklore effect, because it's like saying, you know, someone is really big and they can beat up a lot of people, Now, that will be relevant to, you know, regular people. So, for instance, if you want to play tennis on a court and the court is occupied by that person, that may affect a person's ability to or inclination to go and play at a time when that person would be playing. But it wouldn't affect, for instance, law enforcement agencies' ability or inclination to go and question them when they know that they will be found at that time, because they'll be using tools that are impervious to those considerations. And what will be the only thing that will be relevant is whether or not they have guns or, you know, physical stuff like that can be measured, that has an element of regulation or legislation governing how that needs to be dealt with. So the fact that they're big or generally capable of beating up people is not going to matter. The only thing that will matter is whether they are carrying any weapons or you know, so on and so forth. So, or whether they have bodyguards or how many people are there, you know, tangible things. So the fear aspect of it has a disproportionate effect. And the other problem that it creates, apart from the fact that, you know, there's a house of cards which collapses very quickly, is that the agency is often caught in the dark about the extent of culpability of the people or the vulnerability that it has to the person, because it would have expected all the people to be doing their job, but the people were affected by, you know, the propaganda and they weren't doing their job, but they also didn't tell the agency that all of this stuff was happening. But a large number of them have not been doing what they should have been doing, and that basically creates an environment where the whole agency would then collapse in that conflict. So that's basically the model.
Yeah, I mean that may sound very logical, makes sense.
I know.
And, you know, as long as you've got the facts behind it, which of course we
would. No. This is not about facts. This is about the way in which, like, people work, and it's a product of the nature of things. So it's like, yeah. So
I was just going to say, if you put forward a theory, that's fine, and it makes perfect sense. But then you got to support your theory by the facts that represent that's what's happened.
In that case, yes, that's right. So, but what I'm saying is that the theory in itself is invaluable because one, it contextualizes that what we were doing for a particular purpose, and two, it also clarifies that we're not, or I'm not rather, just empty-headed and
a random vigilante trying to.
Yeah, not just that, but also, I think there's the other question of whether there's any meaning to what I'm doing in a substantive sense, or whether it's, I think that it has some consequence, but it cannot be tangibly represented as being generally useful. So that's basically, it will help establish the academic credential.
I think what you're saying. I mean, mean, I was going to say, it makes all perfect sense to me. What you just said, makes all principle. I mean, when you say it's a principle, it's clearly a well-accepted principle. It's found.
No, I mean I'm
Approved, or it's been, you know what I mean? Is it?
no. So Peter, the way you this is, it's not like I'm discovering a chemical.
No. I understand that. I'm just
So-
saying that. Okay.
So the way this works is that you propose something, and it either comes across as self-evidently, logical or sensible, or it doesn't.
Yeah, which I agree it does.
Okay, and then after that, people try to poke hole in it. That's the next.
How can people look?
So normally you would publish this in a journal, where things about psychology or other scientific stuff is published, and then other people will have an opportunity for a certain time, like a stipulated duration, to poke holes in what you've proposed, and they can do it in two ways. Either they can show that empirically it doesn't work, and then explain where it fails, or just conceptually think of scenarios where it would not work, and then if that happens, then if they successfully demonstrate that, then it's, it goes away, what you've said, because of the flaws. But if no one is able to demonstrate any dysfunction in what you're proposing, then it becomes an established way of explaining things.
Yeah. So, sorry, are you saying this is your creation?
Yes.
In that respect, right? Okay. No, that's all I'm asking.
Did you not get that up until now?
No. Well,
This is my stuff. Like, I don't know if I don't know if there is someone who's also done this independently, like the halo effect thing that I was talking about previously, but I don't think that anybody has, because I've read a lot of this stuff, and
sure.
and also
I
it's
agree with what you've been putting forward. I mean, that all sounds very logical. But that was why I was asking the question.
no. This is my stuff, and also it's very specific. Like it's an area where people normally. I mean, to do research in this area, you have to do what I did, which is pick up fights, and because otherwise, if you're just observing as a passive spectator, you cannot create you can't naturally observe the specific things or tests that need to occur to test the very minute details of things. So I've fought these things in a way that fed the experiment, and that basically is the key to it. Now, I'm gonna share a document which clarifies where I'm doing this. I've done quite a bit of it already. Now, there's a couple of things that I wanted to quickly tell you. Firstly, I think I'm gonna finish this, and then we should do an affidavit and say that's how we're going to expose Gorton. I'll probably do it myself because it'll look artificial if you're saying that this is what I'm doing. But the main problem we have is that because it intimately affects you and not me, like it's more of a violation of your human right than mine because of the license thing. That there's that, but I'll probably say in my affidavit that you agree with me and blah blah blah, and like your rights are getting affected and blah blah blah. So I think that should do it for now. It's sort of a non-controversial thing that you're already against him. Now, the other thing is that while I was researching this, so I started working on this on the basis of common law and the constitutional enforcement of it. But then I started looking into whether there were any statutory provisions that also enforce them, and I found a lot of them. So there are lots of sections of the Charter of Human Rights and Responsibilities. It's basically sections 7. It's in the document. I'll share it with you. Now, they basically give us a lot of ammunition to go against Gorton. So, for instance, if so a principle of statutory interpretation is that the authority is not deemed to have power to adversely affect someone's rights unless the statute clarifies that they do. And if there's any ambiguity about whether or not it can the exercise of power may legitimately adversely impact some of your rights, then the law must be interpreted in a way that goes against that sort of interpretation, that goes against a scenario where your rights are adversely affected by an exercise of power, unless the statute clarifies that. And then there are additional protections built in to enforce that. Now, what this means is that your right to due process in criminal proceedings cannot be abrogated. It cannot be indirectly infringed but by the exercise of power that has not been determined to be legitimately capable of adversely affecting that right. And there are lots of protections built into the law, and they're specified in the document that I've created. Now, where a person thinks that that is happening, they have a right to add the Attorney General to the proceeding, and the Human Rights Commission to the proceeding, to basically say that the court has determined or is determining that to give effect to the law, it must be interpreted in a way that the rights are being abrogated without there being an explicit expression to indicate that. In very few circumstances that can be the case, but when that is the case, then the Attorney General must be informed so they can, have the law amended. So it's a check in two ways. One, it's a check on the legislature, but also it's a check on the court. So basically we do the affidavit and we say that he's doing this for a dishonest purpose and he's doing this and that we want to add the Attorney General and we want to add the Human Rights Commission to the proceedings. We will say that we're doing the appeal and blah blah blah, but we add those people. We say that we want to add those people to the proceeding, and make all the other criticisms of him that we've said. Do you understand?
Yeah, no.
And then he's fucked.
Would sound like he'd have an issue there on the human rights argument.
He can't have an issue. You have a right to add. It's not.
No. I'm saying he would have an issue in that he has.
Yeah, he's fucked. He's badly fucked. He's so badly fucked, like you can't even. I will So I came across the other thing that happened is I came across this beautiful article which I'd saved from earlier, and I appreciated aspects of it better now. So what the writer said, I think it's a judge, what they said is that this statutory interpretation is actually the most innovative area of law now because of things like what I'm doing. So what he said is that because of technology and advanced computational tools and like a different mathematical approach to things, people are contextualizing laws against a much broader context of common law principles and other laws in a way that they previously could not, because A, knowledge was limited, B, they weren't using computers and mathematical tools. So what he said is that now basically you can revisit all the court's decisions that were based on statutory interpretation and legitimately uproot them, because you're basically using a far greater data set to examine the validity of those decisions. And he said this is like the most evolving area of law for good reason. And that's exactly what we're doing. So, sorry? So basically, what we say is that the decisions that Gorton has taken cannot be justified on the basis of the statutory thing. And I mean, in that article, there's so many things about the way the court needs to take decisions. I'll send you the article as well. But basically, what it says, it reinforces everything that we've been saying, that you can't take a law at face value and think that if it literally allows you to do something, or a superficial reading of it shows that, then it allows you to do that. You have to consider every aspect of things, and it's called contextualism. You have to consider the purpose of the act, whether it was passed for that purpose, whether the area of law in which it is operating, it operates with those principles, so on and so forth. So in your case, that would be legal privilege. So basically what they said is you cannot have a situation where you're interpreting a statutory provision in isolation such that it is repugnant to the act itself and the context in which it operates, the purpose for which it was passed and the context in which it operates. And that there's a High Court decision that recently came out which said that the approach that you only consider those things in the case of an ambiguity is wrong. It should be the foremost consideration. So even more than the literal wording of the particular provision. So first you have to consider the purpose of the statute, blah blah blah. So basically he's completely fucking vulnerable on all of that front. And the other problem for him is that and this is the whole folklore effect thing that I was talking about. Because I raise these things repeatedly, the plausible deniability argument is gone for him. Like, the fact that he never thought about it or this or that. That's all basically gone. And the credibility thing is also gone because we've got him on lies. So basically we show this to him and we'll exhibit the article as well. In fact, there was one thing which it said Yeah. So it also said that no act operates in isolation, and basically the constitutional context in which it must operate is also a foremost consideration. So basically, the legal privilege thing, they cannot do what they've done. So ultimately, the theme in all of this is that the Legal Services Board exists to protect legal privilege first and foremost, and to enforce it, and then doing something that is fundamentally repugnant to it is, antithetical to the purpose for which they were created.
Yeah.
So, and we say that is the effect that his decisions are giving, and that is the constitutional question and the charter question that we're raising. So we add the people to it. Now he will basically have to come out and say, no, I will not let you do that. Like, what else can he do? Do you know what I'm saying?
Yes. Yeah.
And he will appear even more fucking stupid and corrupt. So that's what we do now. We basically say that this is our plan, and this is what we're doing. Like, we make an application to add the thing. So we do an affidavit today, and we utilize the hearing tomorrow to say that this is what we're doing, and that's why we didn't do the subpoena thing. Yeah, so that's basically the plan, and I'm gonna finish the document for that. What do you think about that?
No, I mean, look, what you said there, it sounds logical. Everyone asked me, why are we worrying about the subpoena thing?
Why are we worrying about the subpoena thing?
Because we're raising this issue, is what you're saying there.
No, because without the subpoena thing, like, I don't understand why you're asking that.
No, you said.
Because tomorrow's hearing was scheduled for the return of a subpoena that we haven't issued.
Yeah, I understand that, but you were saying, well, we're not worrying about it. That that was your word, not mine.
Ah, okay. Sorry. I thought you were asking why we're worrying about it. Okay. By that, what I meant was that this is why we didn't issue the subpoena, because we knew that he would reject. He was going to dismiss it.
Right. Okay.
And the problem with and this is the problem with him dismissing it. Yeah. He then gets to spin the narrative that we're issuing oppressive subpoenas, and then we come across as attacking a judge for making legitimate decisions.
Yeah.
So he didn't let us issue a subpoena that was more, nuanced or limited. He wanted us to issue a wide subpoena so he could reject it. That's what we say to him. And the other issue is that, he rejected our applications to he dismissed our applications for the protective cost, blah blah blah. We never fucking made those applications. What happened is he basically said, you file these documents by this date and that will be your application. We never filed them. And then instead of saying they have lost the opportunity because they didn't make it, he said he dismisses our application.
And there was no application.
Yeah.
Yeah.
I mean, that's fundamentally fucking dishonest.
Yeah, no, that's sneaky, tricky. Well, that's probably just him being.
No. It's dishonest. And also, when you're a judge, your actions are not attributed to incompetence. Your actions are presumed to be deliberate. and the propensity of the things that he's done, adverse things that he's done, it's not, it cannot just be a random coincidence that, you know, yeah, so it's deliberate. And it's also clear because he addressed, I sent 2 emails, Lulu sent 1 email. He addressed both of my emails, he didn't address hers. So I had said that we don't want you to consider because of the recusal application, blah blah blah. Lulu said that if you reject the recusal application, give us more time to file the thing. And he didn't address that part.
Right.
And then he specifically said that they've been asked for more time. So yeah. Anyway, we point all of these things out, and we just attack them and we say that we need the Attorney General to be added because we have a right to add them. And anyway, we filed the constitutional notice and all the other things, and you know, we say that one of the issues we're raising is that we're arguing that the judge is corrupt and is deliberately trying to take adverse actions against us, and he's basically not willing to address that issue of his corruption. Yeah?
Yeah, well, he's not doing that, is he?
No, he's not. I mean, we've said that he needs to determine that. Whether or not he's corrupt is another consideration, but he's basically saying that he doesn't have to decide on factual basis.
Yeah.
So we raise a constitutional thing about, you know, whether or not a judge can actually do that. And like, you know, if you're doing it facetiously, he should charge us. We made a IBAC complaint as well now, so it's a separate criminal offense to make a complaint without any cause. But you know, we have cause. Like, no one can. It doesn't have to be a winning cause. It just, there has to be a basis, and you know, a basis that can satisfy that you that there is an apprehension that the judge is not following the law and deliberately not following the law, or recklessly not following the law because they want to either keep something from you or give something to someone else that is unlawful. So in this case, it's, you know, him trying to protect the bar, and also, you know, trying to push through on the LSPC mandate. So we say that. So yeah, I mean, it will necessarily take it to the next level after we do this, which I think will be, you know, helpful generally, because
take it to the next level.
Sorry?
What do you mean by take it to the next level, as in the argument?
As in the confrontation with Gorton, because I mean, it will be extreme for him to prevent us from, like, firstly, he can't stop us from filing a constitutional notice and serving it on everybody, the attorneys general and blah blah blah. Then he would literally have to say that we're wrong and there's no human rights issue that arises for him to stop us from adding the attorney general.
Mm-hmm.
That would be an extreme and patently dishonest thing to do, because there's clearly a human rights issue that arises.
Yeah, no, I agree with that.
So it's,
In respect to that.
yeah, and by the way, it's like, it's so many human rights. It's you know, freedom of conscience. It's freedom to you know, participate in various affairs. It's the right to legal representation. It's right to property and making a living and blah blah blah. And due process. So all of the and equality before the law, because they didn't enforce the law in your case. So we say that we're arguing that those have been infringed. He's saying that that is irrelevant because the statutory body doesn't have to consider that. That's prima facie the sort of conflict that there is a mechanism to address in the charter. Do you get what I'm saying? So we say that if the effect of what he's saying is that there is an inconsistency. So basically, the legal requirement is that if the law requires a suspension of the operation of human rights, then at the time of the passage of the bill, the person who's sponsoring it needs to provide a certificate. Well, they need to provide that anyway, certificate of compatibility with human rights, and then in that certificate they need to identify those things, and then there's another person in the House or Parliament that is responsible for making sure that has happened. And then if for whatever reason a bill has passed and those things have not been identified, the moment they're caught in a proceeding, they need to be flagged to the Attorney General. So then it can be passed back to Parliament to have that certification amended. Do you understand what I'm saying?
Yeah, I understand.
So we're saying that the effect of what Gorton has said is that that act must be read so as to necessarily suspend the operation of human rights.
Yes. So in other words, it's not allowed to comply.
That's right.
Yeah.
That's right.
Typically got to be contained in the act or in the act or in the or there was.
They need to have a disclaimer in the act that this act or these parts of the act exclude the operation of human rights considerations.
Yeah.
So basically, the act will need to be amended.
Yes.
Do you understand? Like, we're playing at a whole fucking different level than these fuckers. Like, they can't even identify the statute that they will rely on, and we're basically raising constitutional questions about it. But that's what it is. Like, he's anyway. This is what I was talking about. The more they lie and cheat, because the whole process is foolproof, if used properly, they create very serious issues then. So it's like the whole thing that the crying wolf thing. Do you understand what I'm saying? Like, then the whole village is looking for a wolf instead of